I built the compliance infrastructure that kept Hargrove Regional Medical Center alive through 3 federal audits, not helped build, not contributed to. I designed the 340B drug pricing program controls, wrote the Medicare cost report reconciliation procedures, and created the internal audit framework that the OIG examiner called one of the most thorough self-assessment systems we've seen at a facility this size. I'm telling you this not to brag. I'm telling you this because 6 months ago my new COO walked into my office, sat down across from my desk without being invited, and told me that my position was being restructured. His brother-in-law would be taking over regulatory compliance, effective the first of the month. I smiled at him the way you smile when you know exactly what's coming and the other person has no idea. I've been in healthcare compliance for 19 years. Started as a billing auditor at a small orthopedic group in Columbus, worked my way up through a regional hospital system in Tennessee, and landed at Hargrove 11 years ago when the place was still recovering from a failed joint venture that had left the finance department in shambles. The CEO at the time, a measured man named Dr. Aldridge, who'd run the clinical side for 20 years before taking the top job, hired me specifically because Hargrove was under a corporate integrity agreement with the HHS Office of Inspector General. A CIA is not a suggestion. It's a legally binding settlement document that requires the covered entity to maintain specific compliance functions, submit annual reports, and allow unannounced federal reviews. Failure to meet CIA obligations doesn't result in a fine. It results in exclusion for Medicare and Medicaid. For a hospital that derives 63% of its revenue from government payers, exclusion is a death sentence. I spent my first 2 years at Hargrove rebuilding everything from scratch. The previous compliance officer had left documentation so incomplete that we couldn't reconstruct the audit trails the OIG required. I hired 2 additional staff, implemented a compliance hotline, rewrote every policy manual, and personally conducted department-by-department training across all 4 campuses. When the CIA concluded after 5 years, the OIG sent a formal letter acknowledging our performance. Dr. Term, Aldridge framed it and hung it in the lobby. That was 6 years ago. Dr. Aldridge retired. A new board came in with a mandate to cut costs and modernize operations. They brought in my COO, a man who'd spent the previous 12 years running supply chain and facilities for a hotel chain. A hotel chain. His name was Whitmore. I'll just call him my COO. And from his first week, it was clear he viewed the compliance department the way most non-healthcare executives do, as a cost center that produced nothing visible. He wasn't wrong that we produce nothing visible. That's the nature of the work. What I produced was the absence of catastrophe. The first time he questioned my department budget, I walked him through the 340B audit findings from the prior year, a third-party review that identified $2.3 million in billing errors that we had caught and corrected before submission. He nodded the way people nod when they're not actually listening. The second time he questioned my head count, I showed him the CIA final report and explained, slowly, what exclusion from Medicare would mean for the facility's operating revenue. He said he understood. He clearly didn't. Then the acquisition came. A regional health system out of Charlotte, I'll call them the acquiring group, had been in quiet discussions with Hargrove's board for about 8 months. The deal was structured as an asset acquisition, not a stock purchase, which matters enormously for compliance purposes. In an asset acquisition, the buyer assumes operational responsibility for the facility and, critically, inherits the regulatory relationships, including any ongoing OIG oversight obligations, CMS certification status, and state health department licensure. The deal was valued at approximately $58 million. The board had been told the transaction could close within 90 days of signing. I found out about the acquisition the same way most department heads found out, through a Friday afternoon all-staff email that was written with the cheerful vagueness of someone trying not to say anything legally binding. I requested a meeting with my COO the following Monday to discuss the compliance implications. He fit me in for 20 minutes at the end of the week. I came prepared. I had a 14-page memo outlining every regulatory touchpoint that would require disclosure, review, or renegotiation as part of the acquisition process. CMS provider agreement assignment, state licensure transfer in 3 states, OIG disclosure protocol for the prior CIA, DEA registration continuity for controlled substance handling, Joint Commission deemed status transfer. HIPAA Business Associate Agreement Review across 47 vendor contracts. I laid it out clearly, with timelines and risk levels for each item. My COO looked at the memo, looked at me and said the acquiring group had their own compliance people. I said with respect, the acquiring group's compliance team handles their existing operations. They don't have independent knowledge of our facility's regulatory history. Someone with institutional knowledge needs to manage this transition, or we risk a gap in required notifications that could delay or derail the transaction entirely. He said he appreciated my thoroughness. Then he told me about the restructuring. His brother-in-law, I'll call him the new hire, had apparently been between jobs for about 4 months. He had a background in corporate HR and had done some compliance-adjacent work for a staffing company. My COO used the phrase compliance-adjacent work for a staffing company. My COO used the phrase compliance-adjacent with apparent sincerity. The new hire would be taking over my role. My COO wanted me to spend the next 3 weeks transitioning everything over and training him on the key systems. I asked one question. I asked whether the board had been informed that the transition was happening concurrent with the acquisition process. My COO said he'd handle communicating with the board. I nodded. I gathered my memo. I went back to my office and I sat very still for about 10 minutes. Then I called my attorney. I want to be clear about something. I didn't leave Hargrove because I was angry. I'd been angry before in my career, passed over for promotions, credit taken by others, budgets cut without explanation. Anger wasn't the issue. What I felt in that moment was something closer to the feeling you get when you're watching someone walk toward a clearly visible hazard and they're too confident to look down. I wasn't worried about myself. I was worried about the hospital, about the patients, about the staff who would lose their jobs if a federal exclusion shut the place down because someone didn't file the right form at the right time. But I also understood something my COO did not. I had no legal obligation to stay, and more importantly, I had an obligation not to train someone to perform a regulated function they were not qualified to perform in a way that created the appearance of compliance without the substance of it. That's not a technicality. That's a principle that healthcare compliance professionals take seriously, because the consequences of false compliance are worse than acknowledged non-compliance. My attorney reviewed my employment agreement over the following 2 days. Standard severance provisions. No non-compete clause that covered compliance work within the healthcare sector. A notice period of 30 days. I submitted my resignation letter on a Wednesday. 30 days notice, professional in tone, no mention of the acquisition, no mention of the brother-in-law. I thanked the organization for 11 years. I meant it. My COO called me into his office within the hour. He wanted to know if this was a negotiating tactic. I told him it wasn't. He asked if I would at least extend my timeline given the acquisition. I told him I would honor my 30-day notice period in full and would make myself available to answer procedural questions during that time, but that I wouldn't be conducting training sessions for my replacement. He told me I was being unprofessional. I told him that conducting a formal training program for an unqualified replacement, creating documentation that implied the hospital had adequate compliance oversight when it did not, and doing so during an active federal acquisition review process would be the unprofessional act. I said it calmly. I wasn't performing calm. I genuinely felt it. I'd been prepared for this conversation for a long time, even before I knew the specific reason I'd be having it. He didn't have an answer for that. What followed over the next 30 days was, from my perspective, a masterclass in what happens when an organization mistakes confidence for competence. The new hire was given my office, my email signature block, and my title. He was introduced to the acquiring group's due diligence team as Hargrove's Chief Compliance Officer. He attended the first 2 due diligence sessions without me. I spent my last 30 days completing every task in my transition documentation, archiving 11 years of records and writing a formal compliance status report that I submitted to the full board, not through my COO, but directly to the board chair, which my reporting structure technically permitted. I did this not as a warning shot. I did it because it was the right thing to do, and because 11 years of building something means you don't just walk away without making sure someone knows exactly what you built. The board chair sent me a polite acknowledgement email. I don't know if she read the full report. My last day was a Tuesday. I cleaned up my office, said goodbye to my team, stopped in the cafeteria to get coffee because I'd been getting coffee there on Tuesday mornings for 11 years, and I wasn't going to skip it on the last one. Then I drove home and sat in my driveway for a while before going inside. My wife asked how I felt. I told her I felt fine. She knew me well enough to leave it there. I had already lined up consulting work before I resigned. 2 healthcare systems that needed 340B program reviews and a critical access hospital in rural Kentucky that was preparing for a CMS survey. The financial transition was managed. That wasn't the part I was sitting in the driveway thinking about. 3 weeks after I left, my phone rang. It was a former colleague, a woman who'd been in the billing department at Hargrove for about 8 years. She wasn't calling to catch up. She was calling because something had happened in the due diligence process, and she didn't know who else to call. The acquiring group's legal team had requested what's called a regulatory clearance confirmation, a standard document in healthcare M&A that requires the selling facility to certify its compliance status with all applicable federal programs. CMS provider agreements in good standing, OIG exclusion database clear for all employed and contracted providers, state licensure current and unencumbered, the prior CIA fully discharged with no outstanding obligations. The new hire had reviewed the document. He'd signed it. The problem was the OIG post-CIA monitoring period. When a facility completes a corporate integrity agreement, the OIG typically maintains what's called an independent review organization requirement for a specified period after the formal CIA term ends. In Hargrove's case, that monitoring period had a final report due within 90 days of the acquisition close date. The CIA discharge letter was accurate. The IRO reporting obligation was a separate, subsequent requirement that existed in a different set of documents. Documents I'd filed in a specific folder, flagged for attention, and listed explicitly in the compliance status report I'd submitted to the board chair on my last day. The new hire was apparently not aware IRO obligations could exist independently of the CIA discharge status. He'd certified full regulatory clearance without knowing to look for it. The acquiring group's counsel caught it during secondary review, not because of any notification from Hargrove, because one of their attorneys had worked on a similar transaction years ago and thought to pull the full OIG correspondence file. When they found the outstanding IRO obligation, they did what any sophisticated buyer's counsel does in that situation. They stopped. Not canceled. Stopped. A formal transaction hold pending satisfactory documentation that Hargrove could fulfill the IRO reporting requirement on schedule concurrent with the acquisition close. The acquiring group requested a 45-day extension to the closing timeline, which under the terms of the letter of intent triggered a renegotiation clause. I found out from my former colleague. She told me that during the emergency meeting that followed the transaction hold, my COO had been asked by the board whether the compliance team had identified the IRO obligation. He said the matter was under review. One of the board members apparently asked where the outgoing CCO's compliance status report hadn't been flagged earlier. There was a silence in the room, my colleague told me, that lasted a noticeable amount of time. The board chair had read the report. She just assumed my COO had reviewed it too. I'm going to pause here and tell you something about what the following weeks felt like because I think it matters. People assume that when something like this happens, when the consequence you saw coming from 3 exits back finally arrives, you feel vindicated, triumphant, righteous. I didn't feel any of those things, at least not purely. What I felt was tired and a little sad. Not for my COO, who had made choices and was experiencing the consequences of those choices. Sad for the facility, for the nurses and the lab technicians and the dietary staff and the billing department women who'd called me and the patients who had nothing to do with any of it. An institution is not the people who mismanage it. Hargrove Regional Medical Center had been serving that community for over 60 years. That meant something to me. It still does. I received a call from the board chair about 10 days after the transaction hold. It was a professional call, measured and direct. She asked whether I would be willing to serve as a compliance consultant on a limited engagement basis to help resolve the IRO documentation issue and assist with the remainder of the acquisition due diligence process. She was specific about scope, timeline, and compensation. She did not mention my COO. She did not apologize on behalf of the organization, which I respected. That wasn't the conversation either of us needed to have. I said I needed to review the scope of work and would respond within 48 hours. I called my wife. She said, and I'm quoting directly here, "You already know what you're going to do." She was right. She usually is. I reviewed the engagement letter carefully. My attorney reviewed it. The scope was specific, the liability protections were appropriate, and the compensation reflected the urgency and complexity of the work. I accepted. What followed was 8 weeks of the most concentrated compliance work I'd done since the original CIA remediation 11 years before. The IRO documentation issue was real but resolvable, the obligation was current, the underlying program data was intact, and with the right organizational effort, the final report could be completed within the acquiring group's extended timeline. I worked with a former IRO contractor I'd used before, coordinated with Hargrove's legal team, and produced a remediation plan that satisfied the acquiring group's counsel within 3 weeks. The remaining due diligence work took the rest of the engagement. The new hire remained in his position throughout, which I'll note was its own kind of professional challenge. We were professionally civil. I didn't undermine him. I did my job. There were moments in those weeks when he asked questions and made clear just how much he hadn't known he didn't know, and I answered them as completely as I would have answered any colleague's question. That's not generosity, that's just what the work requires. The acquisition closed. Not in the original timeline, the renegotiation had adjusted terms and the final valuation reflected the delay and associated costs, which from what I understand reduced the transaction value by a material amount. I don't know the exact number, and it's not my business to know. What I know is that it closed, which is what mattered for the facility and for the community it serves. I finished my consulting engagement on a Friday afternoon. The board chair sent me a handwritten note, which I appreciated more than I expected to. My former team took me out for lunch that day. The billing department woman who'd called me brought cookies, which was unnecessary and perfect. My COO was not at lunch. I heard through the general channels that information travels in any organization, that his role had been restructured in the months following the transaction. I don't know the specifics, and I didn't ask. That's between him and the people he works for. I'm back to my consulting practice now, full-time. The 340B work I started before I left Hargrove grew into 2 additional clients in the first quarter. The Kentucky Critical Access Hospital came through their CMS survey without findings, which I'm genuinely proud of. Those rural facilities operate on margins that make compliance support difficult to budget for, and they do it anyway because it's the right thing. People ask me sometimes whether I regret how I handled it, whether I should have stayed, fought harder, gone directly to the board earlier, done something differently. I think about it. The answer I come back to is this. I did the work I was hired to do, for as long as I was permitted to do it, with the integrity the work required. When I was no longer permitted to do it with that integrity, I left. And when the consequences of that gap became apparent, I came back and fixed them. Not because I needed to be right, because the work needed to be done. There's a version of this story where I'm the hero standing over the ruins of my COO's ambitions with my arms crossed. That's not how it felt from the inside. It felt like 11 years of showing up and doing something difficult and largely invisible, followed by the moment when the invisibility finally became legible to the people who'd stopped being able to see it. My daughter asked me, when all of it was over, whether I was happy with how it turned out. She's 24, just starting her own career, and she asks good questions. I told her I was satisfied. That the right outcome happened eventually because someone had built the kind of foundation that makes the right outcome possible even when the people at the top stop paying attention. She asked if that was enough. I thought about the 60-year-old hospital, the rural Kentucky facility, the billing department woman's cookies, the OIG examiner's letter in the lobby that Dr. Aldridge had framed. I told her it was more than enough. There's a particular kind of quiet that follows a long fight. Not victory, not defeat, just the absence of noise you've been living inside for so long you stopped hearing it. That's what I remember most about the weeks after the acquisition closed. Not relief, just quiet. I think about what actually happened at Hargrove. Not the transaction mechanics, not the IRO documentation, but the human sequence underneath all of it. And what strikes me is how straightforward the cause and effect turned out to be. My COO made a decision that prioritized personal loyalty over institutional integrity. That decision created a gap. The gap had consequences. The consequences were proportional to the risk, not to his intentions. He probably believed he was being practical. He wasn't being malicious. But systems don't respond to intentions. They respond to what you actually do. I spent 19 years learning that lesson in the quietest possible way by watching what happened in organizations where the unglamorous work got done carefully versus the ones where it didn't. The difference rarely shows up immediately. It shows up at the worst possible moment, when there's something large at stake and no margin for error, and then it shows up completely. What I kept coming back to, sitting in that consulting engagement in the weeks after my COO's phone call, was the question of what I owed the situation, not what I was owed. What I owed is a version of professional integrity that's really just self-protection dressed up in principle. I won't sign off on this because it could come back on me. That wasn't what I felt. What I felt was simpler and harder to explain, that doing the work correctly mattered independent of whether anyone was watching, and that when I was no longer able to do it correctly, I had an obligation to stop doing it rather than do it badly and call it done. My daughter asked me if that was enough. I keep thinking about her question. I think what she was really asking was whether doing the right thing has any weight when the wrong thing seems to face no immediate consequence. My COO handed an 11-year compliance infrastructure to someone who didn't know what an IRO was. For a few weeks, nothing happened. The new hire sat in my chair, used my email signature, attended meetings. From the outside, it probably looked fine. The consequence was invisible right up until it wasn't. That's the thing about the kind of work I do, and maybe about integrity in general. The value of it is structural. It doesn't produce daily visible output. What it produces is the absence of catastrophe, a thing you can only measure by its presence when it's gone. I couldn't have manufactured what happened. I didn't file a complaint or call the acquiring group's counsel or tip anyone off. I wrote a compliance status report on my last day because the work required it, and then I left. The documentation existed because I'd built systems that produced documentation. The IRO obligation surfaced because someone who knew what to look for looked. Cause and effect, uninterrupted. What I hope, if I'm being honest, is that the people who are just starting out watching this understand that the long game is real, not as a strategy, not as a tactic you deploy to outlast people who wrong you, just as a way of working that compounds over time in ways you can't see yet. 19 years of doing difficult, invisible, unglamorous work produced one moment of legibility. One moment when what I'd built became visible to the people who'd stopped seeing it. My daughter brought cookies on my last day back at Hargrove. She drove 40 minutes to drop them off at the cafeteria before my exit meeting. She didn't make a speech. She just said, "I'm proud of you, Dad," and went back to work. That was more than enough.